Hi everyone, this is attorney Lillian from Lillylegal, where we help our clients get status for themselves and their families using the U.S. immigration law system. So today I want to talk to you about a question actually that I received, which is, can someone enter the U.S. as a visitor and then change to a marriage-based green card? And this is a question that I get asked all the time. So I want to make sure that you know the answer and that you are prepared if you are in the same situation. So if you enter the US with a visiting visa, so a B1, B2 visa, you are legally entering the US. You have been inspected, you went through the airport. The US government recognizes your entry into the US, right? Now, if you go to apply for a green card based on marriage, the question becomes, did you overstay your visit? Okay, that's where it really matters. If you overstayed your visit, it may not be a problem if you're marrying a US citizen and the US citizen is going to file for you to get your green card. In that scenario, you overstaying your visit would be waived because your spouse is a US citizen. Now, if your spouse is a permanent resident, that waiver does not exist, okay? If you overstay your visa and your spouse is a permanent resident, not a US citizen, you would have to file for a waiver. There's a whole other process you will have to go through, but can your spouse file for you? Yes, but just keep in mind, if you have overstayed your visa, it is going to require more documentation and more filings for you to stay in the US while the process is completed. However, if you wait till your spouse is a US citizen, there is a waiver for you overstaying your B1, B2 visa, and you will be able to apply for citizenship. You will be able to apply for a green card based on your spouse being a citizen without ever having to file for a waiver or leaving the US. Now, this is specifically talking about people that came in on a B1, B2 visa for visiting, okay? There's other types of visas that may have other requirements. So do not take this to be a blanket rule for all types of visas, okay? Or all types of entries into the US. So remember, you come in on a B1, B2 visa, you can apply for a green card through your marriage. If you're still in status, your green card holder spouse can file for you if you're still in status, right? Without needing a waiver. If you are out of status, which means you overstayed your visit, your green card spouse can still file for you, but you will most likely need a waiver unless your spouse becomes a citizen before your green card application is processed. Okay? Now, if your spouse is a US citizen and you came in on a B1, B2 visa, just know the fact that you overstay your visa is waived. Now, if there's any other misrepresentation or anything like that, that's not automatically waived, but you overstaying your visa alone, if that's the only thing that that's really wrong in your case, as long as your spouse is a US citizen, that is waived. It's one of the privileges that US citizens get, and you get to benefit from it if you are, of course, the spouse of a US citizen that came in on a B1, B2 visiting visa. Okay, that is all I have for you today. If you have any questions, go ahead and put them in the comments. If you like this video, go ahead and hit the thumbs up button. If you know someone who needs to hear this, go ahead and share this video with them. And if you are watching in a place where you can subscribe, go ahead and hit the subscribe button. And as always, I am Lillian Chukura. I am the owner of Lillylegal, where we do immigration law and we do it well. Bye for now.